us who applied, who took this course. We completed it in 31st March 2019. There's nobody else. There's no other possible kind of candidate who's before your lordship. That's point one. Point two, in those two SLPs that came before your lordship, I think your lordships were under the impression that those who had come were also DLED candidates. They were not. They were not 24-month DLED candidates who had a problem with 18-month DLED candidates. They were B.Ed candidates. B.Ed candidates, which is a qualification.
That is a certain law. B.Ed is not a qualification for primary teacher.
So come to this court and disturb the High Court's judgment is what I'm saying. They absolutely had no locus. But they misled your lordships because we took the SLP out. We filed that also. In the SLP, in the synopsis, they say we are DLED candidates. But then we find that the three petitioners were all three were B.Ed candidates and they didn't have the qualification. They could never have challenged this. It was not 24-month DLED coming against 18-month DLED at all. So they have no problem. 24-month, 18-month, we're all the same DLED. We happen to be in service. So this little...
No, but those persons from Uttarakhand who had approached the Uttarakhand High Court wanted to compete in the advertisement for recruitment initiated by Uttarakhand.
Because we believed that our DLED 18 months was equivalent to the DLED 24 months. We had no reason to believe otherwise. And the High Court, even the High Court, I must tell you, lordships, did not have the benefit of the document I'm showing you, which is the section 29 directions by the MHRD, the expert committee's minutes. The expertise was not of the High Court. The expertise was at a policy level of the central government. The central government says that, look, this concession should be given. They're all full-time teachers. Therefore, they won't be able to do 24 months by 18th.
So what is your problem now?
Our problem is only this. If we are not treated as equivalent...
Who is not treating you?
All the government.
Any document?
All the government. One illustration is page 687 of that large compilation. The one open there. Page 687.
You are still in job in Uttarakhand.
Yes. Most of us are... Those, now I will not speak for everybody. Among the petitioners before your lordship, there are a few who are in service in a particular school who want to move. There are others whose schools are closed and who are without a job. So there are both categories before your lordship, but all of them are in service teachers who finished the 18 months course by the 31st of March 2019. There's no other category here. I'm saying it with some responsibility. I think Mr.
In 301.4, all 94 petitioners are not appointed by the board in the state.
That supports what I'm saying.
They are not appointed at any stage. They are claiming to be in appointment in some management.
So they were not in service at all?
No.
So we will not go into that. How can we go into those questions?
By getting the declaration, compete in the examination. So this, they are ready to put it in affidavit that they have pleaded something completely contrary to what is actually there. No, they have taken the course afterwards as Appendix 9 course in the regulation. It's Appendix 9 course.
In fairness, we are limiting it only to those who have taken the NIOS by 31st March 2019. We're not dealing with anybody else. If Mr. Chatterjee is right, then those people will not get it.
In fact, Lordship,
Millets, we stand by our statement.
2010, the training was not a qualification.
Millets.
I want to first show you this.
In different matters, different states.
There have to be those original petitioners over those and the state.
We cannot.
The state.
No, in your matter, who is your opponent? Which is your opponent?
State.
Which state?
Uttarakhand, man.
Uttarakhand.
Uttarakhand Lordship has dismissed the review. I have the order. That's Lordship will kindly see the number. I have the order. This is Jaiveer Singh versus Union of India review.
said that whatever Uttarakhand High Court has appeared in that matter.
Same matter, no?
This is
Because in that matter, here had come in as the whatever they decide. In that issue was fine. This is not as with the SFP also 24.
We will have to hear the
It
states.
needs to be.
Very good. Very good.
And my lords, we stand by our statement. All of, we were in-service candidates. at the
We will
time.
only consider only such persons who are already in
Yes,
employment
ma'am.
on,
Correct.
on 22nd of September 2017.
Yes, Lord.
Correct. In
In
fact,
fact, Lordship,
that
what
fact,
happened is, in 2010, when the Right to Education Act came, there was no training qualification required at that stage. So, the government gave a 5-year window for getting the training done till 2015. When this was not completed in 2015, it was extended till 2017, and the
So
extension.
we have traced it, we have traced the entire history in our judgment.
Now,
It was a special provision
Yes.
needed to meet that deadline.
Deadline. For the requirement of to meet the
appointed
requirement
under
party.
Act in the state prior to 2017. They are not showing anything, any document.
We are not going to, even if we allow or clarify the order, we are not going to consider individual cases. We will only say
Yes,
That's
that
correct.
such of the
Correct.
teachers who were in employment on that date
precisely.
should be considered as having the necessary qualification under.
State standard, because
In fact,
they are claiming in
the
some schools.
proviso.
Under the state statute, if they were in employment on particular date, we will not.
So, section 23, just one
They are
minute,
saying
one
we
minute,
have
Kunal.
employment with the school.
23
That school
two.
is an aided school or government school, and we don't have a data.
No, so I'm
Let's-
agreeing,
let's be
I'm
additional
agreeing with Mr.
condition.
If
Chagrin.
you don't have a data, if your their services are not rapid, they are out of the code.
That's correct.
Yeah,
So,
we-
so let's, just to help, just,
How can that they claim? How can they claim that?
Their initial appointment was
No,
irregular.
no, but then the NEOS
Yes.
was permitted to conduct that examination only for in-service candidates.
Yes.
And the Nios could not have considered the examination for anybody else.
They have appointment to allow this course to be done by anybody.
No.
No,
they
no,
couldn't have.
not at all.
They couldn't have.
Exactly.
What is he saying?
Who were in employment.
That's exactly.
No, if the Nios has permitted those candidates to appear, it is presumed that they will were in employment.
Well, in fact, section 23(2) provides.
But one thing is clear.
Yes.
We will be putting up a deadline of 22nd September 2017,
Yes.
who were in employment on that day.
No, that's what I wanted to tell you, Lordship. The section requires, and I'm making it against myself, I need to be fair. Section 23(2) proviso of the Act says, provided further that every teacher appointed or in position as on 31st March 2015. 2015, that's the cutoff date, 31st March 2015, who does not possess minimum.
Also, then we'll put it only such persons who were in employment on that.
Absolutely, that's the correct, that's the correct.
23-2.
सब वो बाकी सब एमएस में वगैरह भी नोटिस दे देना नोटिस रिटर्नेबल 4 weeks. That's what we are saying. We have,
In all MAs also, notice needs to.
no further hearing. We'll only be clarifying this position.
Absolutely.
So that is being misinterpreted because I don't think that.
So just, I mean, if there won't be any further hearing, let me show you one page, page 686, which I was just showing you in that fat volume. It's a notice by the government of Assam, which refers to your lordship's judgment and says, the advertisements were prepared and published in compliance with the order dated so-and-so, and I hear of SLP so-and-so, where it is stated that the qualification of 18-month DLED acquired from NIOS is no longer a valid qualification to be eligible for fresh recruitment to the post of teachers. They said this is with the
We'll clarify that.
just clarify.
That they will be entitled only if they were in service on 15th of.
On 31st March 2015.
2015.
So you issue notice in all the MS. Returnable. When can they be served?
As soon as we have served, notice has gone, just one, notice has gone in all 9 MAs already. In the review, we are taking fresh notice from your lordships. If your lordships will give us Dasti, we have served them, but give us Dasti as well. We'll serve them again.
Returnable on 11 December.
11 December is fine.
city, my lords, needs 4 weeks time to file our plan. for this.
What is your stand? You have supported the petitioners before the High Court. Now you can't change.
I'm supporting.
Then for what?
All are supporting but arguing also.
So should we keep it in December or January? What is
December. was the idea. This small clarification. I mean, there doesn't seem to be much cavil.
returnable on 10th of December?
So wait.
Liberty to serve the state government through standing councils.
Great.
कोई 3:30 बजे